Professor Nikki Padfield and Martin Jones, who's CEO of the Parole Board, for bringing us all together on this platform tonight. I'm also very grateful to Cambridge University and of course for the Parole Board for being our virtual hosts today. Now we have an awful lot to get through this evening, so I hope it's okay if I'm going to be quite strict about the timetable. So just to be clear, we've got 3 topics that we're going to cover, and I'm going to ask each presenter to present their topic for around 15 minutes, and then there will be 5 minutes for a response. And then I'm hoping there'll be about 10 minutes for questions, which can be for either the presenter or the responder. And please do make clear who your question is for. Now, I will be taking questions from the question and answer box. There is a chat function. Please do use that if you want to have a sort of discussion as we go along, but I'm not going to be monitoring that for questions. I'm going to be monitoring the question and answer box. So please put your questions there. After all of the 3 presentations are complete, there will, I hope, be another 10 minutes or so for any other questions that you might have, and I'll be putting those to the key presenters, and I'll then turn to Tom Hawker-Dunson to draw together some conclusions from the evening. And then there will be a pause, and we'll all reconvene, I hope, again together for the second part of the session. So at this point, I am going to hand over to Professor Nikki Padfield for the first section of the evening. I'm just going to tell you, I'm sure that all of you will know Nikki, but I'm just going to give a very brief introduction. So Nikki Padfield is Professor of Criminal and Penal Justice at the Law Faculty at Cambridge University, where she's worked for more than 30 years. She was a Master of Fitzwilliam College between 2013 and 2019, and is now a Life and Honorary Fellow. I believe that Nikki has been studying parole for over 20 years, and she's written some very influential books on parole, and so I'm very much looking forward to what she has to say. The responder for this session will be Peter Rook. Peter Rook is the Judicial Vice Chair at the Parole Board. Peter joined in February 2020, which was fantastic timing because I did actually get to meet Peter in person before we all went virtual. Peter was called to the bar in 1973 and was appointed a Queen's Counsel in 1991. In June 2005, he was appointed a Senior Circuit Judge and sat at the Old Bailey until retiring in March 2017. He's also sat as a judge in the Court of Appeal, and he was a coroner between 2017 and 2019. So Nikki, if it's okay at this stage, I'm going to hand over to you.
Thank you very much. I shall share my screen and hope that it works well. Can you see that? I think that's now visible. So I have the privilege of starting off these 2 seminars with painting a picture perhaps of the context of this root and branch review, where we're at today in relation to parole. And I'm really grateful for the Parole Board for co-hosting this with the Cambridge Centre for Criminal Justice and the Institute of Criminology here in Cambridge, because this is really, really topical. Actually, I think it's been really, really topical for all of my working life. And it's like saying prisons are in crisis. Well, prisons have been in crisis for most of my working life. So when does a crisis stop if it's perennial? The changing context, which I think we should think about for parole, I'm going to start off my presentation now with quite a narrow focus on the Parole Board, widening out to hope that this root and branch review is something rather broader than just looking at the Parole Board. The Parole Board was set up in 1967, and wow, has it changed since 1967. In 1967, it was a very small advisory board, largely experts, judges, psychiatrists, criminologists. It's interesting, really interesting how it's changed. We've now got, I don't know, going up to 300, I think. And the criminologists have virtually disappeared. The psychiatrists are not very visible. So the balance of membership has changed very, very dramatically. And what they do is really, really different. Then they were advising early release. For those serving much shorter sentences, after 6 months, you could ask the local review committee to recommend to the Parole Board, who would recommend to the Home Secretary that you got released after 1/3 of your sentence or after 6 months. Something else which I think was really important then were the interviews with prisoners. I know one member of the Parole Board who came back onto the Parole Board in recent times who really, really regretted the absence of those much more informal interviews that prisoners had with local review committees in the early days. So it was a body that looked at early release, and now I would say it's a body which is looking at late release, because everyone who has their case considered by the Parole Board has served the punitive part of their sentence, either the lifers or the recalled sentence prisoners. I'll come to who they are a little bit later on. So dramatic change. Anyone who thinks about the rules for the Parole Board as set up in 1967 is wrong. Most of the drivers of change, I would say, have been politics, some really interesting early reviews. What are the key issues today? Delays is something often highlighted. Whether the Parole Board is too cautious. Of course, we're never going to be able to agree about the level of risk that should be taken, but I think it's worth starting off by pointing out how few people are reconvicted for serious offences. Serious further offences happen, but they're often people who are released automatically, not by the Parole Board. The Parole Board is a very small cog in a very large machine, and I think the machine analogy is quite useful. Are there too many cogs in the machine? As soon as one cog silts up, there's a real problem. There's a real problem, I think, of stop, start, stop. My Parole Board hearing's coming up, then eventually it comes up, then I don't get recommended for release or directed for release, and so I wait for another 2 years. There are lots of issues there, which I'll come back to briefly. The changes have been enormous number of changes. I'm not going to go through those changes. The 2012 Act of Parliament, really important for getting rid of IPP, but everybody knows IPP hasn't really been got rid of because there are still loads of IPPers in prison and they're being recalled at a high rate. The 2015 Act was very interesting, producing parole adjudicators to decide on recalls, but that was never introduced. Those changes, sometimes I feel that people want to blame the courts or annoying lawyers. I would absolutely say nonsense. Don't say, oh, we had to change our processes because of Smith and West or Osborne and Booth. Those cases are decided by, in my eyes, very wise, very cautious judges. Lord Bingham in Smith and West, it's a really powerful judgment by Lord Bingham, I think, thinking about the individual stories of Mr. Smith and Mr. West. Lord Reid, the current president of the Supreme Court, very careful in Osborne and Booth, thinking about the practical importance of fairness. So I think don't ever blame the courts for these changes, which have been thrust upon the Parole Board. They're very basic, lowest common denominator issues of fairness. I couldn't resist my bottom comment there. The Prime Minister is going to Brussels later this week, we're told, because he believes that face-to-face meetings are more effective. I shall use that a lot in my great nervousness about video justice or hearings held by video links. The Prime Minister thought it was necessary to go to Brussels and see somebody face-to-face. That is a list of the enormous number of changes since the John Warboys case. John Radford, I'm not going to go through it, happy to answer questions on it. What has driven this review? The Conservative Manifesto told us that we will introduce tougher sentencing for the worst offenders and end automatic halfway release from prison for serious crimes. For child murderers, there will be life imprisonment without parole. That is obviously a really punitive message. No discussion, I think, about why halfway release is inappropriate. Remember, it used to be 1/3. Why is 2/3 better than halfway? We should be discussing all these issues, and the implications for the prison population are, of course, huge. I'm really pleased to be followed this evening by two people who, one will be talking, Joe, obviously, about reducing reoffending. And then we have Julian Roberts talking about the role of public opinion, popular punitiveness. And those are really central problems, I think, for setting the scene for our second webinar tomorrow. What should be the drivers of root and branch change? Lying in bed last night thinking about this presentation, as one does, I got diverted at about 3 o'clock in the morning to the meaning of root and branch and what we meant by a root and branch change. I'm not sure that the government is really planning a root and branch change of parole, but it does depend what you mean by parole. If it's simply talking about conditional early release, everyone who comes out of prison is on parole in our system. And I hope they're thinking about everyone, because sentencing is not a one-off event. It is a process. People live their sentence for years and years, indeed for the rest of their lives. And I think it is a really important function for us to think about how prisoners progress through their sentence. Obviously, at the moment, the Parole Board is largely looking at indeterminate sentences. There's a really interesting recent article by Mansell, Smith and Morrison on the paradox of Scottish life sentences. The main paradox they're talking about is the paradox of the very high rate of life sentences in Scotland, and yet it's meant to be a welfareist criminal justice system in many ways. I think there are actually quite a lot of other paradoxes that they identify in the article, which are just as interesting. They talk about, for example, that victimizing offenders by keeping them in longer than they need to be kept in prison doesn't promote the welfare of victims. This offender-victim dichotomy, which is often thrown our way, is actually deeply paradoxical. No time to explore it further. I'm very conscious that all the speakers that we've got lined up for this evening and tomorrow evening are white and privileged. A lot of the academic articles actually are focused at understanding desistance from the point of view of those living sentences. And I commend to you those recent articles by Beth Weaver and Ben Crew, but again, I think I have no time to talk about them. The number of people released from prison under determinate sentences, the vast majority go anywhere near the Parole Board. Recall, we should be really, really worried about the number of people being recalled. I've already mentioned it with the IPPs. Look at the number of people on probation. Probation throughout my working life has been the sort of poor relation of prison probation research, but it's vital that we think about probation, and it's vital that we take support for victims seriously. That doesn't mean giving them false hopes. The difficult question for me is who should be doing the driving of this root and branch review of parole? And the Parole Board is a very, very cautious animal. And it would say, and I'm sure that Peter Rook will say, we have to be cautious. That's how we're set up. We work under directions issued by the Minister of Justice. And I hope that the Ministry of Justice will be brave enough to realise that empowering the Parole Board would strengthen the Parole Board and make the whole process much, much more effective and efficient. And I put there in parentheses my same point about the Sentencing Council. The Sentencing Council has been sitting there watching sentences get longer in recent years because it doesn't see itself driving sentencing policy. That's for the Ministry of Justice. Well, I wish that it was a bit braver and that the government would ask it to be braver in worrying about penal excess. It is probably for the Ministry of Justice, HMPPS, typing error, to worry about the implementations of sentences. And I think the relative role of executive and judiciary is very, very difficult. I would want the Parole Board to be turned into a court, more of a court than it is. But I also think those drug review courts we used to have were very, very useful. Problem-solving sentence review courts. Are we going to have that kind of broad review? Though, of course, judges think their independence stops them speaking out as much as they should. I like the concept of shockability because I've met many judges and parole board members who will say, I had a terrible case yesterday, but they don't ever shout about it. They don't think it's their job to talk about that beyond having another glass of wine when they get home in the evening or whatever. We need really to empower those working in the system to focus on promoting social integration for people with convictions. And I think there are really important issues for the parole board, which shouldn't be seen as a guardian of keeping people in prison, but it should be seen as a body which is there to promote progress, to monitor progress, to complain when progress isn't happening as it should be. And yes, the burden of proof argument is one of my mantras. Of course, the state should have to prove the necessity of detention once you're post-tariff. Final slide is my vision for root and branch change. I decided it was a question really for Capability Brown or a landscape designer to think about root and branches. And the root causes of crime definitely need worrying about. Then have we got too many branches? Are we doing sentencing? I think has become much too complicated. Release has become much, much too complicated. I've mentioned already the problem that we are a load of white and privileged speakers talking about these issues. Black lives certainly matter, and we all have our pet miseries that we bang on about in the prison system. Lots of people talk about IPP. I would rather at this moment talk about accomplices to murder. A lot of young Black men serving extraordinarily long sentences because they hung around with somebody who murdered somebody else. There are lots of issues for us to worry about and to take equality, diversity, and inclusion in our society much more seriously. Is it too much to hope that our penal system might become an engine of change and social justice for victims and offenders and for all of us? I end on that point. That was a whizzing tour of what this review might be about. At the end of my slides, I've put 2 pages of references, and we're going to put the slides on the website at the end, but that's my short introduction.
Nikki, thank you very much for that whistle-stop tour. That was great. Can I please remind everybody that I'm going to be taking questions from the Q&A box. So we're not getting very many questions at the moment, but I'm sure there are loads of questions. So please put your questions in the Q&A box. But I'm now going to turn to Peter Rook, who I've already introduced, to respond to what Nikki said. That'll take about 5 minutes, and then, as I say, I'm going to be coming to questions. So Peter, over to you.
Thank you, Nikki. Your whizzing tour was as clear and hard-hitting as ever, gave us much food for thought in our joint quest for social justice for victims and offenders. Context, let me start with some immediately attractive opportunities. The perception of the Parole Board's independence is all important. Its role is so often misunderstood. Shouldn't it become a freestanding court, so its actual independence is there for all to see, rather than nestling somewhere where it might be treated as an also-ran? Wouldn't that help public education? And in line with this, surely it's time to give the Parole Board the power to enforce its own decisions. Let me give you a powerful example. When we are asked to perform risk assessment in a complex terrorist risk offender case with disputes on the facts to resolve, surely the board must have powers to enforce its own directions. So isn't the first question, is the system right? Do we need major structural change to achieve greater social justice? Can we build on what we have without jeopardizing what we have? As Nikki predicted, I'd say high quality oral hearings where risk is assessed in a fair and effective manner. I would say that certainly the Parole Board is not the sole occupant of the driving seat, but it's at the wheel. It's delivered major improvements and will continue to do so. Just stand back for a moment. With fresh eyes, I've been struck by many highly positive features. In 2000 to 2001, the board held 2 172 oral hearings. Last year, over 8,000, 30-fold increase. Same time, board released 114 indeterminate sentence prisoners in 2000 to 2001. Last year, it was nearly 10 times as many. So even 10 years ago, we released just 258. The trend is there for all to see. We've made progress. And the Parole Board has been transformed beyond recognition and has evolved. It's clearly got a strong governance. Nikki has mentioned the important post-war boys developments, such as reconsideration. It's weathered and is weathering the pandemic with great efficiency, even though it's faced with this huge increased caseload and numbers still rising with the addition of the rarer offenders. Yes, the Parole Board needs to be ruthless in its measures to achieve a more efficient system without compromising fairness. We already have the process of getting panels to take ownership. That's well underway. The loud message is, if further information really is necessary, adjourn, don't defer. 97% of our hearings now progress the case, either with the hearing or the panel taking ownership. The Parole Board lies at the end of the system, and it's now acknowledged by those who really understand the system that delay is often not to be attributable to the Parole Board, and it can influence other agencies. So often, the delay is caused by failure to comply with directions or not enough approved premises to support rehabilitation, non-availability of early programs, the failure to use timely psychological risk assessment. Now, all these can be assisted by maybe by the proposed Parole Oversight Board and Inspectorate. So lastly, to what extent should the Parole Board be involved in sentence planning and monitoring progress beyond an annual review? Should we be treading with care here? Because obviously there are potential pitfalls which come from adopting a more interventionist policy. We might be able to reduce delays and improve throughput, but there's a potential tension with the need for the Parole Board to be an impartial court. Well, obviously, recommendations for open conditions becoming decisions, that's a good start. Should we be more open to exploration of some further possibilities in this area? We cannot just cherry pick from a system like the French based on a totally different model and approach to punishment. The Parole Board couldn't possibly be involved in sentence planning in all cases, but are there cases where we could have a greater involvement? Is it already happening? For example, case conferences to discuss the prisoner's needs. Those very difficult, complex cases with prisoners making 3 steps forward and then 2 backwards. Those who will never present as the ideal rehabilitated prisoner. Those intractable cases, the rump of the IPPs. Should we be strengthening Section 9, the end of our decision letters? Should it have a greater utility than just insight for the next panel into the thinking of the last panel? At the moment, we're discouraged from doing so with the terms of our referral. Should we be giving a greater steer in this category as was envisaged in Osborne? For instance, supervise the needs of stuck cases, maybe recommending a program needs assessment or even timetabling future reviews. Or would this greater involvement risk compromising our objectivity? Does it come with a price? Finally, don't underestimate what the Parole Board has done to improve the system and what it will do in the future. In doing this and influencing others to do the same, it contributes to a greater coherence.
Peter, thank you very much. I'm now going to select some questions out of the question and answer box that we've got. And I'm going to do, the first question is from Lee Brown, and it's saying, what more can be done to prioritise people with an IPP sentence? Nikki, what's your view on this?
I think it's really, really difficult. I would introduce a rule which said that once you had done double your tariff, you would automatically come out, I think, which would concentrate people's minds. And of course, some people have done way more than double their tariff. The problem with that is that they're likely then to be recalled. And once you've been recalled, it's just like a game of snakes and ladders. It's just as difficult to get out again once you've been recalled as it was to get out the first time. And in some ways, it's more difficult. And again, I'd be interested in a Parole Board response to this. My feeling is the Parole Board people must think, oh dear, we let him out once and he failed. And setting people up to fail is something that I've heard again and again. I don't think it's a useful concept. You should be setting people up to succeed. And if there aren't enough approved premises, and if there isn't enough support, and if there isn't enough everything else, well, we have to shout about that rather than say we keep people in prison because we mustn't set them up to fail. I think it's a really, really difficult problem. So, of course, we shouldn't have people who got a 2-year IPP in 2006 still in prison, but clearly they are people with very unsteady lifestyles, otherwise they wouldn't still be in prison. They clearly need a huge amount of support. The probation service needs so much more attention and resources because of these poor overworked probation officers who are having to supervise difficult people, challenging people in the community. And there is no easy answer, but yeah, we must all go on shouting very loudly because all is not well in the world of IPPs.
Thanks, Nikki. You said you wanted to hear from the Parole Board, so I'm going to turn to Peter on this one.
Right, well, the predictable answer would be simply to say, as the law currently is, we have to do our job. But clearly, there's a strong case for a political move here. There's a complete lack of proportionality. Those of us who passed IPPs years ago would have had huge qualms if we'd known that this was going to be the current situation. But we applied the law. And of course, there are other political solutions. You could apply a slightly different test. For instance, you could say that you should only retain in custody those where there's a proven imminent risk.
Thank you. I'm going to go on now to a question from Dean Kingham. You've addressed it a little bit, Peter, in what you said, but so I'm going to come to Nikki on this, whether you think the Parole Board should have more role in sentence planning or even category status.
Absolutely. I think the Secretary of State's directions should, at the moment, the Secretary of State's directions, when they start cases off, which I think is very odd, why don't prisoners negotiate and initiate hearings? Why doesn't the Parole Board initiate hearings? But when the Secretary of State for Justice initiates hearings, the message is loud and clear, and we're only asking you to recommend release or otherwise, or possibly transfer to open conditions. Please don't do more than that. Whereas if I was the Secretary of Justice, I would be saying, please tell us anything that you find in the system which is worrying us, and tell us what else you'd like, etc. So it's a very, very odd system, I think, that the Parole Board is not being asked to do a much broader review. Now, one of the things which is my concern at the moment is that this is a very narrow root and branch, i.e. not root and branch at all. Ideally, sentences would be considered by judges, I think. I think it's very good for judges too. A lot of judges are very nervous of going to prison. I know one judge who said not very long ago, I don't want to go to prison. I'd find it really difficult to send people to prison if I visited them regularly, which, you know, to my mind means exactly that judge should have to go to prison every day if they're sending somebody to prison and worried about it. So I think the sentencing review courts are really good for judges and magistrates so that they engage with the reality of the lives that people are having to maneuver through either in prison or in the community once they're released. Again, another really important issue that we haven't touched upon. A lot of attention given to suicides in prison, rightly, much less to suicides in the community. Coming out of prison after a long time is a deeply difficult situation. And yes, some kind of review. Go back to the Parole Board after a year if you've done really, really well, so that the Parole Board can learn what went well for people. Sadly, with recalls, Parole Board only comes across sad stories or unsuccessful releases. They hear very little about successful releases.
Thanks, Nikki. And we've just got one more minute of this section because I do want to try and keep us on time. There are some great questions coming in, but we've got time at the end, so I will pick up these ones. But I just wanted to pick up one point, Nikki, that you made. You said we were a very cautious organisation. I'm talking about the Parole Board. And Peter, I wondered if you wanted to come back on whether you think we're a cautious organisation.
No, I think that you could say we're cautious in that we apply the law, But as I set out in my short talk, I think the Parole Board has really been quite innovative when you look at what it's done over the last few years. When you look at an innovation like the reconsideration mechanism, which I would have thought will go from strength to strength, and of course will become even stronger should we become recognized as the court that we clearly are.
Thanks, Peter. I'm now going to move on to the next section. As I say, I will be coming back to some of these questions at the end when we'll have a sort of general panel discussion, but I'm now going to move on to the section which is looking at what measures actually increase public safety. The presenter is going to be Dr. Jo Bailey, and Dr. Jo Bailey is head of the Psychology Services Group in HM Prison and Probation Service. She's got nearly 30 years experience in the prison service, and she's an expert on the role of forensic psychology in our criminal justice system. So Jo is going to be speaking for about 15 minutes. The response is going to come from Fergus Mcneal, and Fergus Mcneal is a professor of criminology and social work at the University of Glasgow, where he works in the Scottish Centre for Crime and Justice Research and in Sociology. Prior to becoming an academic in 1998, Fergus worked for a number of years in residential drug rehabilitation and as a criminal justice social worker. So Jo, I'll now hand over to you.
Thank you, Caroline. I'm now going to try and do the magic of sharing a screen, which fills me with a level of fear whenever I try and do it.
Jo, while you do that,
Right.
I'm going to ask people, please put questions in the question and answer box, which will be oriented towards Jo now, please.
Great, thank you. So I can see the screen, so I'm hoping everybody else can. So thank you for asking me to participate today. The formal session is what increases public safety, which seemed quite ambitious, I thought, overall. So I specifically want to start by emphasising the fundamental importance of considering any individual as a whole, as well as them being distinct from others, however similar they may seem. And that's something that I think you'll notice I repeat as I go on. And what this means is we need to understand how someone comes to be in the position they're in, their experiences they've had, and how they've ended up to be in custody or on a community licence. And quite clearly, this will vary from person to person. And importantly, we need to focus on what an individual can build on, whether that's themselves or when there's more difficult for them to achieve, how those around them can assist. And to emphasise again, we must recognise that what works for one person won't necessarily work for another, even if on the face of it, it looks like it should. Everyone's got a very different pattern of interwoven factors. Oh, and now I find that my slide doesn't move. That could be a problem.
If you use the arrows, that will use rather than your mouse, probably.
Yeah, using the arrows, it's a slightly dilapidated laptop, so I had to hit the arrow slightly harder than I planned. So just a really quick overview of risk assessment before I talk about some wider activities. From a practice perspective, we'd expect that all risk assessment should not just be about identifying concerns, but we should be trying to identify ways to reduce or manage any risks that are identified. And to do this, we take a formulation approach which helps develop and understand to follow up and assist in reducing the likelihood of future reoffending and enhance public safety. And importantly, risk of reoffending is a changing thing, which both internal and external events can impact on. Quick picture in terms of assessments of risk of reoffending, that we can use both static and dynamic factors. Static are historical factors which tend not to change. Dynamic factors are the ones that we can work with. And the demand for psychological risk assessment within the Parole Board has significantly increased over recent years. This is largely for the fourth generation tools, which you can see on the bottom right of that slide, which combine professional judgment with a focus on future planning and risk management, but can also, we find from the Parole Board, include more diagnostic assessments. For example, different personality disorders, which from a risk management perspective may have more limited value. I'm not sure if this increase is due to changes in the type of caseload, the increased membership of psychologist members on panels, or some other factor or combination of events. But what I do know is that risk assessment can rarely, if ever, bring certainty. But by taking a strengths-based formulation approach, whilst working in collaboration, we can have an approach which reinforces the importance of protective factors and have a better chance of creating a meaningful picture to those charged with making decisions and supporting individuals in their progress. We need to also, of course, be aware of limitations of risk assessment and resist the urge to simply seek more and more information and updates and assessments. So, a strengths-based, individualised approach to assessment, and moving on to models of rehabilitation that we can draw on to help guide our thinking. So, for example, the What Works approach tells us that individual change is necessary and that attitudes and thinking are key drivers of criminal and antisocial behaviour. It reminds us to focus on the principles of effective rehab, namely risk, need and responsivity, known as R&R. There's a decent evidence base supporting this approach, but it can't stand alone. It's also worth saying at this point that personally, I find the language of R&R sometimes quite unhelpful. The term need for me is a personal red flag because it can easily become quite patronising and imperious, even when it isn't intended to be. I try very hard not to talk about people's needs. I'm sure you'll find one somewhere in this presentation, but I try and talk about what may benefit, what strengths people can build on that may help them. I don't think any of us react well to being told what we need to do. In rehab terms, we might also refer to the Good Lives model, which aims to enable people to develop strategies which help them flourish by focusing on building the positive, not focusing on the gaps or the disorder. It's future focused, not harking back to the past, identifying and building on strengths, teaching pro-social skills to enable well-being with an aim to reduce reoffending and hence increase public safety. And of course, over recent years, the desistance approach has gained significant popularity. I'm slightly nervous mentioning desistance when I have Fergus following me, but I think I can refer to it as a journey with potential false starts, which places importance on social capital and relationships. Like a positive psychology approach, desistance focuses on hopes and strengths and would tell us to focus on individual and societal well-being rather than maladaptive behaviour. Each of the rehab models underpins the work that we're trying to do to enhance public safety, and they all have a slightly different focus, but I'd argue that in essence, they are all fairly well integrated and speak to each other well. At the heart of the model is the need for a clear, holistic approach with shared agreement that it's important to have a full understanding of an individual in order to enable them to build their strengths and capabilities, to help them thrive and reduce their likelihood of future reoffending. So any assessment, intervention and risk management plan should try to achieve these things. So I'm going to start with a couple of approaches which we think can be unhelpful in reducing reoffending. So we see some general approaches that tend not to work, despite the fact that some of them seem quite intuitive. But we know that deterrence, including scared straight approaches, doesn't work. And the evidence around victim awareness and other insight building tends to be quite poor when that's all it is. Of course, there may be other outcomes from things like victim awareness and insight work. But despite this, we still see a number of requests for victim awareness and insight work in the parole context. And the reasons they don't work are worth knowing, as we can try to avoid this in our wider thinking. Sorry, I'm having a bit of a technical fail. So simply helping people to see the impact of their crimes, the consequences of their decisions, or preventing them from engaging in certain behaviours for a limited amount of time doesn't appear to help people change behaviour in the long term. That's supported by behaviour change research generally, which suggests that people need not only the motivation to change, but they need the capacity or the skills and the opportunity. We also know that decisions to act are not always rational and can be influenced by biases. So, for example, can result in a tendency to prioritise short-term gain over more abstract long-term losses. And social psychology would also point to another possible explanation for the lack of impact of interventions that rely on extrinsic motivation to desist from crime. Extrinsic motivators, even in the form of reward, can undermine intrinsic motivation and the autonomy of the decision. This is not to say that developing intrinsic motivation alone is sufficient to bring about behaviour change, of course. But we'd say that insight-orientated interventions intend to improve intrinsic motivation to change, but without building the skills to do so differently in the future, will fail to have an impact on recidivism. Right, so on this slide, so if we think that often offending is about achieving a valued outcome, this is a perfectly normal human drive. It's just that in some instances, achieving the goal manifests in harmful or antisocial behaviours when the outcome can't be achieved by pro-social means due to either internal or external factors or a combination of the two. Once we, and importantly the individual themselves, understand this, we can support them to identify activities that can add to their repertoire rather than simply removing or managing a problem as the only option. However, although we can teach skills and support individuals to apply them, we can't force individuals to use them. And for some, there'll be a heavier focus on internal capabilities, and for others, it'll be the external. Sometimes those internal factors are about feeling lost in a system and not having the capacity to move forward. And those of us working with those individuals can help them find a way through. A concrete example I'd give is the Joint Parole Board and HMPPS Action Plan for IPPs, where we focused on identifying potential pathways for post-tariff IPPs and working with the progression panels within the NPS to maintain a focus on this group of prisoners and the varied pathways and services available. Clearly, we can't just identify a pathway. We need to engage and collaborate to find the way forward with the individual. Where we have a lot of internal and external obstacles and very few strengths, we could expect to see an individual struggling to meet their goals via these pro-social means, in which case we need to work holistically and strategically to ensure they're able to make the most of the opportunities available to them. If we think that once we can conceptualise what our own valued outcomes actually are, it's possible to identify ways to achieve those goals. This goes for all of us in life, not just those who've offended, and we've all experienced the need to own what is happening. So we need a collaborative approach in order to ensure and maintain agency. Effective community support and supervision is also key, with those involved at all stages in community supervision understanding the strengths-based model as well, and supporting individuals to understand the model themselves, and also support them as a shared activity in helping them make their own decisions and think through the consequences of their actions. This needs us always to recognise that everyone is different and will also respond very differently to reintegration into the community if they've been absent. So we see a positive and strengths-based approach therefore fits with positive psychology, R&R, the Good Lives model, desistance approaches, as well as supporting an approach to assessment. So moving on to the pathways model used by HMPPS. The same model is repeated in some shape or another in many publications. I just put 4 of them up there in slightly different ways. But in effect, we know that the areas listed on that slide, the 7 pathways, give us the areas to focus on to help people reduce their risk of reoffending. In no particular order, which I also suspect doesn't match the order I just listed them on the other slide, I'll just quickly highlight a couple of the areas. Firstly, employment. We've seen that vocation, education and work training in prison can have a significant impact on reoffending. It also matters that the employment is appropriate and meaningful and provides a sense of achievement. And this can be as a stepping stone role where someone sees the longer game. It's quite a busy slide. I'm not going to go into detail, but I think the slides will be available later. Similarly, with accommodation, we know that accommodation and the lack of accommodation is a long-term issue for many. And for some, it's not simply finding accommodation, but supporting those other areas of their life which can also impact on homelessness, such as substance misuse, that are also important. And finally, and I've just been told that where my notes are, the computer's about to time out, so this might be fun. The final pathway I want to touch on is the attitudes, thinking and behaviour pathway. This pathway aims to build on the skills, abilities and attitudes that will support an individual to lead a crime-free life. Whilst there are a range of approaches within this pathway, we see a significant focus on offending behaviour programmes. I quite deliberately come to this pathway last, as such programmes must fit into the wider context so that participants understand why they're undertaking them, what they may gain from them, and how these gains may help them live the life they seek. We also see a high demand within the parole process, similar to as Peter was just mentioning, for assessments for offending behaviour programmes. But that's even when those involved in the case may know that they either aren't a suitable candidate or that they may be better focusing on other pathways first. And of course, given the powers of the Parole Board, such directions will be met. But when we hear individuals say things like, I need to attend an accredited programme because I have to for my parole, we might wonder if the individual is fully bought into the programme as a collaborative and meaningful way to achieve their goals. And referrals and assessment directions for programmes can somehow become about the resource to complete them, rather than how meaningful they are for that individual at time. When someone doesn't recognise a programme provides an opportunity to develop strengths to meet their goals, I would say the programme is of questionable value. It loses a sense of collaboration, agency and understanding and becomes simply a hoop. Similarly, we should not think that change will necessarily happen whilst an individual is on a programme or soon afterwards. The desistance literature would tell us that for many, change can take time with other building blocks needed along the way, and that it's not always a linear path. But it may be that a programme might have planted a seed, but it was not until some time later when the circumstances were right that they're able to develop their thinking and make the changes that they choose to make. Accredited programmes are the most evidence-based rehab activity in this strand, but they're not suitable for all and should only ever be seen as part of the rehab offer. And of course, when people's material circumstances are very deprived, more than a programme needs to be considered. So in my view, programmes are important but insufficient as part of a rehab approach. They're one part of the ATB strand, and the ATB strand is part of a much wider rehab approach. So to repeat myself again, what helps is using a collaborative and strengths-based approach to achieve the shifts relevant to the individual, recognising that their experience of imprisonment can also shape this process. This also means considering the sequence and combinations of approaches that might be helpful to assist people in making the shift that's identified on this slide.
Joe, I'm just a bit conscious of time, so if I can ask you to draw things to a conclusion, that would be great.
I'll do this before my thing times out. I've got one more slide that's disappeared on me. This is the last slide if my computer, however, everything is going a little bit wrong. Right, I'm back on paper. Right, so I'm coming to a close. To enable people to find the hope and identity needed to desist from crime, a range of opportunities, skills, values and affirmation can be derived from various activities that are on offer both in a prison and in the community. The trick is in working in collaboration throughout assessment and identifying activities and services to help to find the right approach with the right individual at the right time. I'd say that we often see a focus on programmes within the ATB pathway without always thinking about the programme in context or without recognising the impact a non-collaborative ask for someone to complete a programme can have on undermining their agency in the process. Parole Board outcome letters cannot currently direct a rehab activity, but often they name what it is they think should be done. But by naming the vehicle rather than focusing on the destination, there is the potential to reduce the intrinsic motivation. I'll now finish with two questions I regularly ask myself: different ways to support people and what can help impact on reducing reoffending and increase public safety. Do we think there is an overemphasis on offending behaviour programmes within the parole process as a means to demonstrate reduced risk? And if so, how do we break that cycle when this very focus is potentially undermining the gains that the programmes could potentially bring? And that's me. Thank you for listening at some pace.
Thank you, Joe, for that very thoughtful presentation. If I can ask you to stop screen sharing. Perfect. Okay, thank you, Joe. And I'm now going to ask Professor Fergus Mcneal to respond. And Fergus, if I could ask you to take about 5 minutes, then I'll have enough time for questions as well. Thank you.
I'll try to be very brief. I'll start just by saying I claim no expertise on the parole system of England and Wales, but I am going to try and make a connection between Joe's excellent account of evidence-based practices in pursuit of rehabilitation and how we might think about developing a legitimate, coherent and constructive parole system within a broader criminal justice system, which has those characteristics: legitimacy, coherence and a constructive approach. But I have to start where we are, which is that if we want to pursue public safety through criminal justice, then at the moment we're doing it in a system which is confused and contradictory, and the source of its turmoil, I believe, is largely to be found in a combination of a lack of clear and responsible political leadership, which sometimes, to my mind, verges on political cowardice, and at worst is characterized by political opportunism. So I think that's the reality of where we start in trying to develop and improve these systems. So I'm going to make 4 points. First, what's the nature of the confusion? Well, first of all, our systems, not just parole, but often sentencing and onwards, we face a profound confusion in the pursuit of purposes which are not contradictory, but which are commonly set against one another, or between which contradictions emerge. So here, in discussions of parole specifically, I notice the slippage between notions of retribution and the pursuit of retribution, and notions of prevention and risk management. And quite often when people are talking about whether people should or should not be released, like war boys or like people convicted of terrorist offences, there's slippage between what, if we're honest, is a desire to see people who we find extremely distasteful and to some extent fearful, a desire to see those people continually punished and repunished and punished more severely perhaps than they were sentenced to be punished, and thinking in a more cold and rational way about the extent to which risk has been reduced and can be managed, and the slippage between the retributive impulse, which also stretches towards a vindictive impulse, and the careful consideration of risk is one which I think is very hard to avoid in parole systems. But there's a third aspect, or a third purpose of sentencing more broadly, which we also must consider in the same space, and that, of course, is the pursuit of rehabilitation, and through it, ultimately, the reintegration of people who've been punished. Now, in that space, we often get locked into the evidence-based practice discourse, and we focus on thinking about what it is that we have to do in order to enable an individual to change their attitudes, change their behaviour, and perhaps change their future. And I don't for a moment seek to devalue or marginalize the importance of that kind of work. I think it is critically important in a humane system of justice. But what it can neglect is the recognition that reintegration is a right of people who have been punished, not just a duty upon them, but a right. If we believe in a proportionate and fair system of justice where the punishment fits the crime, and if the courts have determined what a proportional punishment is, then to allow punishment to continue beyond that which is proportionate by refusing to reintegrate or failing to reintegrate people who've served their punishment is a moral failure on behalf of society and of the system. So we have to recalibrate and reconsider the way that we think about rehabilitation and reintegration as rights that the system and the state and society owes to people that it punishes, and not merely as something that we require them to do before we consider allowing them to live once again among us. But I'll add a second point here, which is evidence-based and not so much concerned with questions of principle. Allowing people to be reintegrated is essential to the safety of all of us. And that, to me, is one of the key lessons of desistance research. If people are placed and held in places of exclusion, whether that means in the penal estate or whether it means back in the marginalized communities and the isolated households, or in a position of exclusion from the labour market, or in a position where they are vilified within their communities, if those people aren't given a path to inclusion and integration, then risk is sustained by our reaction to those people rather than by something which is inherent within them. So a reintegrative system is a system that pursues safety. Of course, a reintegrative system is at odds with a system which is excessively precautionary. And I'm not going to make a claim about the system in England and Wales because I haven't studied it sufficiently to sustain such a claim. Nikki has, and I noticed that in describing the current parole system as a late release system, there's certainly a suspicion that that system has become excessively precautionary. Now that's not effective in pursuit of reintegration. And to make matters worse, it undermines all of the kinds of work that Joe has just so carefully articulated to us. If we have psychologists and social workers and probation officers and educationalists and work trainers in prison investing significant resources in the development of people held in our prison system, but we pursue precautionary approaches to decision-making about them, and then excessively precautionary practices in the post-release supervision of them, then we will undermine the investment in personal rehabilitation that Joe's work and the work of many of our colleagues aims to achieve. So I'll finish by making a call for a system which gets past this confusion and contradiction by thinking much more carefully about pursuing reintegration in 4 domains which are interdependent and interlocked: Joe has told us a great deal about what I would call the domain of personal rehabilitation, the work that we can do to help people develop themselves, develop their skills, develop their attitudes, develop their capacity to live better lives. That work remains vitally important. If it meets a system of social exclusion, which is unaddressed, and social rejection, which is unaddressed, then we're failing to socially reintegrate. And we need to get serious about thinking about how we can enable communities to better receive people returning from prison. Linked to that, we need to think about judicial or legal rehabilitation, meaning the restoration of full citizenship to people who have paid their debts. And this includes in relation to questions around the disclosure of criminal convictions, which, as we all know, creates huge barriers to participation in the labour market. So if we want people to be less likely to reoffend, then we have to clear the path to the pursuit of a legitimate and satisfying life. And so long as we sustain barriers, legal, moral, social, we defeat our own ends, and we create a society which is less safe because of its fearfulness, because of its precaution, because of its anxiety, and because of its failure to clearly articulate what we demand our justice system produce. And after all, the first demand of such a system is justice and fairness. The second is crime control. And I think that's the order in which we have to think about this problem. Thank you.
Fergus, thank you very much. I'm now going to take a couple of questions. There have been some fantastic questions that have been put in the question and answer function. I'm going to start with one for you, Joe, which is obviously COVID-19 has been a really difficult issue. It's an anonymous question, but the question effectively is, COVID has had an impact on prisoners to being able to access your services. What are you going to try and do to kind of catch up on that?
Yes, obviously the regimes within prisons have been curtailed to some extent, and that's varied from site to site depending on what the situation was, what the infection control was, what the Public Health England advice was. In terms of psychology work and in terms of programmes, as they're two slightly different strands. So we are working through Parole Board directions for psych assessments as they come, and we're working with the Parole Board listings team to make sure that we're able to prioritise the cases based on when they're going to be listing. And thus far, I am touching Formica as I say this, we are managing to cope with the Parole Board demand. I get the feeling that when the Parole Board went into remote operation, they got through quite a lot of work, which sent quite a few directions our way. And we're doing okay. We're doing okay in terms of just eating into some of the sort of the, I don't want to say backlog because it's not actually a backlog, but eating into the reports that need doing. And we've identified a number of different ways of doing that so that just disclosing a report doesn't get held up if we can't do a face-to-face meeting. So we are working very hard to make use of different remote access within prisons as well. In terms of OBPs, we have every prison, I think now bar one, and even that one I think now might be up and running, has restarted programmes. Some of those were the people that were paused when we had to stop previously. Some of those are high priority cases that we're identifying. Our data is improving with that so that we can make sure that we're identifying people who are either going to be approaching release that we want to prioritise, or people who are post-tariff that we want to be prioritising. That piece of work's ongoing, and I completely understand the anxiety caused by some of the delays that we've understandably had to have over the last few months. But we are back on our feet and recovery plans are in place.
Thank you, Joe. I think we've got time for one more question in this section. As I say, there'll be general questions at the end. I'll pick up some of the other issues then. But I'm going to ask this of you, Fergus. Hugh Daniel has asked, are we at risk of wanting to stick more and more labels onto a prisoner by seeking numerous assessments?
I'm not going to, I mean, I find it difficult to answer that question. I suspect it's referring to practices within the system that I'm insufficiently expert to comment on, but I will say this much. I think I think at times parole boards seek a reassurance and security through labels and processes that appear to offer, if not a guarantee, then an assurance that risk, which has been misconceived as residing in the person, has been somehow exorcised from them through a process of psychological or correctional rehabilitation. And I think I'm not arguing that psychological rehabilitation isn't important and that people don't have work that they need to do on themselves in order to address certain issues. But I think a parole system which is too preoccupied with the internal dynamics of what's going on in a person's psychology is missing the point. That what we need to do here is create pathways to reintegration, and personal development is one element of that, one element of 7, as Joe's presentation put it. To be centrally preoccupied on that, specifically through the mechanism of programs, as if they are the magic bullets that make it okay to open the door and let somebody out, is criminological nonsense, to be blunt about it.
Thank you very much for that response. I'm now going to move us on to the last section before we come to sort of general questions. And this section is on increasing public understanding of parole. And we're going to start with a presentation by Julian Roberts. Julian Roberts is a professor of criminology in the Faculty of Law at the University of Oxford and was a member of the Sentencing Council of England and Wales, and advisor to the American Law Institute Model Penal Code sentencing projects. And he is a founding member of the Sentencing Academy. And then we're going to have a response from Angela Cousins. Angela has over 25 years of experience working for the Probation Service and the Criminal Justice Service, following a career in the recruitment industry. In 2009, Angela took on the role as the Chief Executive of the South Wales Probation Trust and was part of the team which merged the 4 former probation areas into a single Welsh trust. So I'm going to hand over now to Professor Roberts for about 15 minutes.
Thank you very much. Can you hear me okay?
Yes,
Great.
we can.
Super. Well, thanks to the organisers for the opportunity to participate. It's a very important and timely event. And just for the occasion, I dusted off a tie. Can you believe it? Oh, you all dumped your shares in tie rack. Not sure when I'll be able to wear this again, but great to be here. And I want to talk about public reaction to parole, and I'm actually interested in 2 things: public knowledge of parole, release from prison, and public attitudes. But I must warn you that there's not a lot to be said in terms of actual data here. You know, I got out my PowerPoint kit and was beginning to assemble some slides, when I realized I had no data to put in the slides. Having done a review, extensive review of public opinion work, prowling around the library and the internet, there is almost nothing on public knowledge of the board and parole, release from prison, and related matters. And that's a big gap in the literature, one I hope to fill at some point in the not so distant future. And it's surprising because there's been so much research on public attitudes to sentencing and parole, beginning largely with Mike's work in the 80s, Mike Huff. And, you know, a good example is a Maury poll conducted in 2004, which is a very good survey, which, using a representative sample and so on, asked the questions about every stage of the criminal process. The police, the CPS, the courts, magistrates, judges, prisons, probation, you name it, everything except parole. And there were all sorts of aspects of confidence and performance ratings, but as you say, nothing on parole. Occasionally YouGov pops in something which is indirectly related, but there's no systematic literature on what the public think of parole and what they know about the function and duties of the parole board. So we can learn a little bit from jurisdictions with broadly comparable parole regimes, and I suppose that include Australia, New Zealand, and Canada. And there, the literature, and I'm pretty sure we could extrapolate to the public in Britain as well, fall into a number of errors with respect to their knowledge. They tend to overestimate the ease and the frequency with which prisoners are released. More significantly, I think the research demonstrates that they overestimate reoffending of people released on license or on parole, known in other countries, and they overestimate or misperceive the seriousness of reoffending. And that's all very unfortunate. And if those findings can be extrapolated to England and Wales, then obviously there is quite a problem. So those are overestimations. And I think in terms of misperception, it's also quite clear that people probably underestimate the amount of time somebody spends in prison before becoming eligible to make an application. And there are a few straws in the wind here that from related polls. There was a poll recently, a question asked by YouGov. The public was asked to estimate the amount of time served in prison by life prisoners before they were released on license. And about half estimated under 15 years. Significant proportion, about a third, I think, under 10. And I looked at the statistics, and I think the actual true statistic is somewhere between 17 and 19 years. So there's clearly a problem of misperception there. And I think it relates to the public misperception of what the releasing authorities, what the Parole Board of England and Wales is doing. That parole, release from prison prior to the expiry of the sentence, complete expiry of the sentence, is primarily something which is of benefit to the offender. It's about rehabilitation. It's about some kind of mitigation. And release is relatively easy to secure, and risk takes a backseat to rehabilitation. I think that's the public misperception. And so that, when I come to talking about what needs to be done, I think that needs to change, because of course the Parole Board is very tightly focused on risk, managing risk, and so on, as we know. I think also there's probably a perception that the Parole Board is relatively secretive, or it's hidden away. People don't really know anything about it. It's a complex environment, the release arrangements in England and Wales. And you can imagine members of the public sort of having a conversation. What's the Parole Board do? Have you heard anything about the Parole Board? And the response is likely to be something, well, yeah, weren't they sort of involved in that war boys business? So there's this perception based on these high profile cases. So this is something that probably needs to change, or to the extent that we can move public perception and increase public awareness of what the board is doing. And of course, it's sort of paradoxical or ironic, isn't it? The board is accused frequently of being too cautious and risk averse and so on, and the public perception is quite the opposite, that they're too easy, letting these dangerous people out all the time. And I think also there's probably a misperception that the board is indifferent to the interests of crime victims, and that's certainly not true. And there's been significant changes. Nikki's alluded to some of those in recent years, and you can't be a member of the Parole Board without having one of the competencies is awareness of victim interests and so on. So quite a few sort of misperceptions to be addressed. I do think there's a bit of a philosophical gap, and this is one of the things that will be hard to overcome in terms of public reaction to how people get out of prison and when and under what condition. And I think I would characterize the public's perception as populist retributivism, because the board is concerned with risk of reoffending and managing that risk and promoting rehabilitation. I think the public is still more focused on the sentencing issues, and so matters that relate to the sentence are still quite high in the public's mind, quite visible in the public's imagination. And I think we saw that with War Boys. They were still thinking a lot about the sentencing of the individual. And more recently, in this business, of the McCourt case, or this factor of failing to disclose the location of the victim. So that's a classic aggravating factor at sentencing, which, and an important one too, in my view. But we're talking about parole, and so the question is, what's the relationship between that allegation, between that factor, call it what you want, and risk of reoffending? So the public's still thinking punishment, retribution, proportionality, and maybe they should be thinking more about what the board is actually legally bound to do, which is to consider risk. So I think in terms of increasing or promoting public understanding, we probably do need to make a better effort, or somebody needs to make a better effort at dispelling some of the misperceptions and providing some easily digestible facts and figures to the public. So I did a review. I sort of sat myself down and said, I'm the chap on the Clapham omnibus. What's all this about parole? What do they do? And what are they trying to do? And what success do they have? So I sort of went to public documents like the annual report of the Parole Board of England and Wales, and I didn't really see this kind of information that I think members of the public want. So obviously the annual report of the Parole Board is not a public education document, but it's got a lot of information. It's sort of quite astonishing wealth of detail on remuneration. And all these KPIs, that stopped me in my tracks initially. KPIs, I think that's key performance indicator. But the only key performance indicator I think that the public is interested in is in failure, in the sense of people released from prison who commit a serious, or are charged with, or alleged to have committed a serious offence. And of course, buried in there, in that report, is the 1% response. I mean, as I saw it in the report, 1% of releases in that particular year involved a serious further offence allegation. And other jurisdictions have done a much better job. The Parole Board of Canada, for example, pushes these statistics. They've got a 5% failure rate, which includes recalls to prison for breach of conditions, technical breaches, not just reoffending. And I think probably the board could do a better job at communicating, in a sense, how well they're doing in managing risk, in the sense that the failure rate is so low. And I didn't really see too much else. The Australian and New Zealand boards and agencies and the Canadian Parole Board put out these myth and perception documents, and they have various reports that address these matters. And I think we could use a little of that. I don't know how effective it would be, but certainly worth a try. And by the way, the tailored review report, which I read, I thought did a better job at bringing out that 1% serious further offence statistic. So I think that's probably worth building up. And another important thing I think the public should be reminded of is the costs of imprisonment and the costs of supervising an ex-prisoner on license in the community. I think they'd be quite interested to learn that. And again, this cost data is part of the public education initiatives in other jurisdictions. More accessible website would be good. I noticed the Sentencing Council has just refurbed its website. It's sort of more user-friendly. And I think something a bit more accessible and public-facing would help the image of the board and release from prison in general, and possibly even something like a parole analog to the magistrates in the community. That's a very successful initiative that the magistrates have been running for years now, where they hold sessions with members of the public, pre-pandemonium, of course, and the Sentencing Council has its "You Be the Judge." Other organisations have got those too. People are given a case to sentence, and then the magistrates explain, or the website explains the logic of the sentence that ultimately was imposed. And I'm thinking of a line of research which is sort of dried up now, in which samples of the public, or properly constructed samples of the public, were given case histories to consider. And there's a sentencing line here where people are given scenarios to sentence, but there's also a run of cases, a run of articles where members of the public are given releasing decisions to take. Here's a profile of the prisoner, here are the submissions of various parties and so on. What do you think? Should he be released, under what conditions, when, and so on? And both those bodies of literature, the sentencing and the parole literature, found much greater concordance than you would expect to find if the public have this very critical, hawkish attitude. And the last point I'd make on sort of promoting public understanding, I think I would inform them more about the way that the public, the victims' interests are carried through and respected at parole. That's obviously a controversial area to some degree. Some people think parole board has gone too far. Some people don't think it's got enough. But from the public's perspective, the public are squarely behind victims, and the board's work and the system's work in general in informing victims and advising them of their rights and so on could very usefully, I think, be highlighted. So that's just a few thoughts. I'm going to stop there so we can have more time for discussion and questions. And thank you again for the invitation.
Julian, thank you very much. And as chair of the Parole Board, that's given me a lot to think about in terms of how we communicate what we do. And I particularly like the idea of myth busting, if I can call it that way. But I will now hand over to Angela Cousins, who's going to respond.
Hello, everybody. And can you hear me?
Angela, yeah, we can hear you.
That's great. Hello. And again, really welcome the opportunity to participate. I've been scribbling furiously and same with Caroline, giving me loads of food for thought, but I'm in the unusual position from the National Probation Service is talking about our lesser known work with victims and our victim contact scheme and the work that I think is critical to how we operate of the victim liaison officers, VLOs, as we know for short. Just start really briefly, I'm conscious of time, but I did want to just share a personal reflection on why I think this work is so important, that it is part of the National Probation Service. When I first decided to join the Probation Service, I actually was quite an active, I was actively involved in a lot of victim work in my own time, so with Rape Crisis and with Women's Aid and other victim groups. And when I made the decision to join the Probation Service, I got a huge amount of pushback, to put it mildly, from a lot of people who really did see I was going over to the dark side. I was there to go and support offenders. My argument then, and still is 27 years later, is that I think the whole system needs to look at how do we reduce the number of victims and reduce the harm, but also support victims through that process. So the victim contact scheme to me is a critical part of reflecting some of the points that Julian said about really just counteracting some of those public protection issues and some of those public perception issues that we're often labelled with. Very quickly then, our victim contact scheme, initial contact with victims, and we have statutory victims scheme. It starts right at the beginning of sentence, and that's not always a good time for people to engage with this process. We find that often people will want to not have anything to do with the process once the court case is concluded. But when they do take up contact, that contact can go on for many, many years. So our victim liaison officers, by the time they get to the point of the parole discussions, have often had a really close working relationship with that family and those individuals. So that discussion usually then starts around about 9 months prior to the first parole review. But as we know, that first parole review may well be an unsuccessful parole hearing in terms of release, or even move on into open. So that can be quite an overly tasking for the victim as well as for the worker to keep that momentum going through what can be an incredibly lengthy process, and we've heard about that today. The other point I'd say is that we're not there to champion the views of the victim. What we're there to do is to try and support the victim to play a role in that process. And I think one of the most important parts of the victim liaison officer's job is to manage the victim's expectations. So that part of their role is to try and explain to them the whole process, which can be complex for practitioners and those of us who work in it, let alone for people who are in the role of the victim of that offence. But also critically to help them to understand and explain the Parole Board test for release. And I think that's something that we need to really emphasise and try and promote actually the work that we do, so that people have a confidence that role of the victim in the process is an informed decision to engage, and informed by good engagement from an early stage, and from a position where their expectations have been, at least if not managed, certainly explained and moderated. At the moment, it's an opt-in scheme. We are hoping that we will see the new victim code in April, and to change that to an auto enrolment scheme. People have to make difficult decisions at the time of sentence, and one of them often is, I don't want anything more to do with this. We find, especially with people who have been involved in the system for quite a length of time, that they'll want to revisit that decision closer to the parole hearing. So that's something that I think will enhance the process. The other thing I just wanted to speak about very quickly was our work to try and help victims to engage in the process meaningfully. And it's actually one of the successes of the COVID situation. Never miss the opportunity to use a crisis to get some benefits, in my view. And one of them is that we've had an awful lot more opportunities to support victims to make contributions remotely. I find it still intimidating. I've been going into prisons for years and meeting with prisoners and staff. I still find it quite intimidating sometimes to go into the prison wall and engage in that environment. And for a victim, that can be a really, really daunting prospect. So I think one of the positives, and that we hope that we'll take into whatever normal looks like after we're through this pandemic, is enhancing that ability of our victims to be able to engage in the process meaningfully by contributing through video links or through recording their victim contact, their victim personal statements, etc. Finally, I just want to finish on that reflection that we were talking about right at the beginning, and Julian Roberts was articulating so clearly. The public perception of the whole purpose of sentencing, which I know Ferguson has raised in the sidebar there, about the fact that there is a desire by the whole system to reduce the number of victims, but that can only happen with meaningful reintegration of prisoners into the community. So one of the really critical roles of the victim contact scheme and our workers there is to try and balance those rights of the victim to have engagement, quite rightly and appropriately, but with the challenges of ensuring that the licence and the licence period is meaningful and really does support the prisoner when they become a licensee to engage meaningfully in the community. So that can be all sorts of things around exclusion zones, that can have a real difficult and challenging sort of problem for the victim to try and get their heads around why can't this person be excluded from the whole of the southwest of England, because I don't want any chance of them ever bumping into any of myself or my family. That balance actually needs to be really carefully trod. And it's one of the reasons why, on a personal level, although we've heard many calls for the victim contact scheme to be taken out of the probation line, I think there is some real benefit of having that awareness of the importance of balancing the rights of victims to participate quite rightly and appropriately within the parole process, but with the need to ensure that we are supporting really good reintegration plans when we take over the supervision of those prisoners leaving on licence. So I'll finish there, and hopefully that's given you a bit of insight into some of the work we do around our victim work.
That's great. Thank you very much, Angela. What I'm now going to do is I'm going to take two questions which I picked out, which I think are oriented towards Angela and Julian, and then I'm going to start picking out other questions after they've been answered, which can be for any of our speakers to respond to. So I'm going to start with one from Cyrus Tata for Julian, which said, would it help if the Parole Board was a court in terms of public confidence?
Well, I think it might do. I should have said, by the way, that I do think there's strong public support for supervised release prior to the end of the expiry of the sentence, and we need to capitalize on that. I think the public, if you look at those, goes back to those Maury surveys where they're asked about the courts, the performance ratings, if I can use that term, from the public of the courts are very positive, that they make disinterested decisions, that they are decisions of with integrity, and so on. And I think that the Parole Board doesn't benefit from that because it's seen as being this agency which is off to the side and is somewhat secretive, and you can't just show up and attend a hearing. So I think if it were more open in that sense, in the form of an open tribunal, that would help. But of course, there are privacy issues and various other matters, so I have to be carefully balanced. But certainly, I think more opening up of the Parole Board. You may remember, a few of you, about 15 years ago, there was a television program which I thought was quite interesting, and they followed board members as they made decisions. That's quite a long time ago now, and I think the more the public see and learn about the Parole Board, the better the image will be.
Thank you. And this one's for Angela, and it's along a similar theme actually. It's from Sue Powers saying, what's your views, Angela, on parole hearings being held in public?
It's a really topical discussion at the moment, as you can well imagine, with some of the proposals we've been looking at. My personal view is that I think there are some real risks involved that we would need to mitigate if that was the case, because of the I think some of the issues I was talking about really around the victims' engagement. I think that's quite a challenge to be in a closed session. I don't think it's a bad idea. I just think we would need to be really careful that we work out what are the risks that it poses, not on a physical level, but the emotional level and the ability for victims to engage. Equally for the prisoner to engage meaningfully. We want these to be meaningful events for everybody. And I think finally, it'd be remiss of me not to mention that there's been quite a lot of debate about how that would impact on our staff and how our staff would feel being in those sort of situations in a more public forum. So I think there's I can see a lot of benefits, I can see a lot of risks, and I think we would need to work that through very carefully to make sure none of those materialised.
Great. Okay, thank you, Angela. So I'm now going to ask questions. They might dot around. I'm going to keep going till 1:45. So we've got about 10 minutes for questions. And I'm going to ask any of our speakers, please, to jump in if they want to answer. So I've got one here from Adrian Grounds, who says, do the speakers think that the Parole Board put undue weight on past offending history, in particular the seriousness of harm caused in the past? Does anybody want to answer that?
I could say something briefly. I mean, I think this is a complicated area in relation to the technicalities of how risk assessment is undertaken. So there's increasing criminological evidence that risk assessments, or rather that the role of previous offending in risk assessment has a shelf life. so that the meaningfulness of previous conviction events tails off after somewhere between 5 and 10 years. It's often said that past behaviour is the best predictor of future behaviour, but the problem is it doesn't stay equally true over time. So there's a tailing off effect. And that means in the case of criminal records that periods, current periods during which offences have to be disclosed are, broadly speaking, too long in relation to the criminological evidence of what the offence is supposed to be telling us or telling prospective employers. I think there's probably a similar risk in relation to the use of past behaviour in thinking about parole decision making. I think a much more careful and holistic assessment of where the person is now is probably much more relevant than the kind of the repeated exegesis of the past, if you like.
Thank you, Fergus. Okay, and I've got another one here, which is anonymous. Well, but it says, given the recent McCourt case granting standing to murder victims' parents to challenge a parole board decision by judicial review following a reconsideration, is the system on its way to giving the victim or victim's family a voice in the substantive decision rather than limited to licence conditions or exclusion zones? Does anybody want to step in with this one? I was thinking maybe of Nikki or Peter.
My comment would simply be it's obviously a huge, huge danger. The reconsideration mechanism, I think, is working much better than I feared, because it's mostly prisoners who are asking for their cases to be reconsidered. There was an interesting question from Andrew Sperling on that, who obviously thinks that it is a dreadful system, that everybody is having their release delayed in case somebody wants to challenge the decision to release them. And I can see that. The reality, I would like to take that one forward, I think, and explore the implications of his question in answering the question which you raise, because the tensions, the pressures are there.
Nikki, thank you. Because in fact, I was about to come to Andrew's question next. So I don't know who would like to pick that one up. And this is just to read out the question. Do panelists view the reconsideration mechanism as an infringement on the Parole Board's independence and undermining the status of the Parole Board as a court-like body? And he goes on to say, which other court or tribunals have a process whereby their decisions are suspended for 21 days and not considered final until they've checked for irrationality or procedural unfairness? So does anybody want to respond on that? Peter, shall I come to you first?
Yes, well, somewhat unsurprisingly, my answer is I don't think it in any way compromises our independence. It seems to me that it's a further guarantee. If you think about the practical alternative, the expense of a JR, the time it takes, and when you think about the 21 days, of course, it's not a set 21 days, that can be varied and reduced.
Thank you. Does anybody else want to come in on this from the panel? I hear silence, so I'm going to move on to another question, which has come from Ben Jarman, who's interviewed a number of people in current research projects who are way over tariff. And he said they were deeply cynical sometimes about the parole process, and one had even stopped bothering to attend hearings. How should the board help with these kind of cases, identify when the prisoner no longer has faith in the system? And I wondered if I'll come to Joe and Julian on this, if that's okay. Joe, is there anything you'd like to say?
Yeah, I think I touched on that earlier when I was saying that there will be some people who are disengaged for a variety of reasons, whether they've just lost hope in the system or whether they don't have their own kind of capacity to engage. And I think we've got a responsibility to engage, to motivate, and to help them try and get through that. It's not a particularly simple thing to do for some people, but I think that's part of what our responsibilities are, to make sure that people aren't allowed really to just throw any hope out of the window. So we've got to be able to hold that for them, work with them, because I agree with Ben. I think there are people who are in that position.
Could I rather teasingly throw it back to Ben Jarman and say I want him in his next research project to write about why these people are rejecting the parole board, because I want to hear more about their stories, because maybe I would be deeply sympathetic to why they're feeling so alienated from the parole board. So hearing more about those stories would be really, really interesting.
Great, thank you, Nikki. Julian, is there anything you'd like to say on this?
Well, I would just add, I was always surprised at the number of people in Canada, number of prisoners in Canada who declined to make an application to their parole board. This is going back into the 80s and 90s, of course. But I do think it's important to find out why a prisoner would decline to participate in the hearing and understand the reasons for it. Although ultimately, you know, if they're going to do that, I think you have to respect their agency to do so. If they have some legitimate grievance in terms of, or some perception that the parole board is not likely to give them a fair hearing, then that should be brought to light and dealt with.
Thank you. And this is a question from another anonymous attendee, and I'm going to come to Joe and then Angela on this, if that's okay. And the question is, do you view there is an over-reliance on psychology assessments for parole hearings that can disempower the role of probation and their role in understanding and managing risks? So I'll come to Joe and then Angela.
I think it's a really tricky one, because I think that psychological assessments are a really useful piece of information. I think all too often psychological assessment is taken out of context, and then the people that are going to be working with that individual in the community are sometimes given a second voice, when actually they should be the prime voice when we're talking about reintegration and how someone's going to be managed. And I think the psychology report should be within that context, not the specialist standalone report, which I think sometimes, not all the time, but sometimes that's how they're regarded.
Yeah, thanks. Jo and I have spoken about this numerous times, and I know she's incredibly supportive of the fact, and if you didn't hear everything she said there, I think we were trying to hear there, it was part of the assessment and shouldn't be the default. I mean, on a personal level, she's putting her hands up. Good. We are very much minded that there needs to be one recommendation through the parole board with a holistic assessment that takes into account all of those professional assessments, be them from the people working with the prisoner during their prison sentence, be the psychologist or anyone else who should be contributing, but we do need to pull that together. And that judgment about what should be presented to the parole board needs to sit with the probation officer, who's ultimately going to carry that responsibility through into the community. Just to say, however, that we do find, it's thumbs up from Joe, good. We do find that, and I don't understand this to a full extent, we need to look into it more, but there seems to be a default to, but what does the psychologist say? But wouldn't that be more important, and shouldn't we defer to that as a judgment? We're working hard, and I know Joe's fully supported this jointly, aren't we, Joe, to try and combat some of that, but we do need to look to parole board members as well to view the probation officer's assessment as holistic, and we've got to improve how we present that so that that's more possible, I think.
So I'm sorry if my my comm system broke down, but actually Angela's pretty much said exactly what I said, so we're all good.
And Joe, it was good enough. Don't worry. And then I think we've got time for one more question, and I'm going to take the question which is from Sonia Clark, who said, how does one make the parole board more reflective of society and representation? And she's thinking of the challenges of the women in the War Boys case and the over-representation of black men as an accessory. And if it's okay, I'm going to come to Fergus, and then I'm going to come to Nikki as the last person to answer a question before we go to our final session. So Fergus, is there anything you'd like to say on this?
I think I would just say simply that, as with the pursuit of accessibility, equality and diversity in all organizations and in all systems, you can't expect that to happen in a society which is structurally unjust. You can't expect that to happen by accident or by default. You have to proactively seek to recruit diversity into the organization in order to address that problem. So the parole board's no different from any other arm of the criminal justice system in that sense. But we can't wait for it to happen. We have to make active steps to address the problem.
Great. And Nikki, is there anything you'd like to say?
No, I think you'd like to say that actually you've made extraordinary advances in that direction and have been, I think, positively discriminating in your recruitment. And well, maybe not, that's going too far, but there's been dramatic change in recent years in the makeup of the parole.
Okay, I absolutely would like to say that, but I'm not speaking with Parole today, so I might just come to Peter if he'd want to cover that.
Right. Well, I think that the figures speak for themselves, and we've taken a proactive approach.
Great. Okay. Well, listen, thank you all. At this stage, I'm now going to hand over to Tom Hawker-Dawson, who's going to draw some conclusions from this session. And just to introduce Tom, Tom Hawker-Dawson is a college lecturer in law and fellow at Christ College, Cambridge. Tom's research interests lie in criminal law and criminology with a focus on sentencing in theory, law and practice. And his doctoral work examines communication and sentencing remarks of Crown Court judges and the impact of video link technology and other recent reforms. So I'm now going to hand over to Tom.
Thank you very much, Caroline. And I should just say that very recently I have in fact joined Girton College, just to add that in there. Of course, I have the task of perhaps summing up a little bit of what's been said today and teasing out some concluding questions. And my goodness me, there are so many things that we have gone through today. It's very difficult, I think, to do justice to all of the wonderful contributions that we've had. So I've focused around, I think, 3 questions that I would say have emerged. And the first one really relates to the depth of this root and branch review. With Professor Nikki Padfield asking at the outset, you know, how deep really is this review? It's described as being root and branch. And is what we're looking at a matter of kind of pruning some of the edges, or should we be expecting this to really be quite a meaningful review that digs deeper into some of the underlying principles behind not just the Parole Board, but the question of release and recall and the meaning of these concepts. The idea that this could be conceived of as a system of early release or late release perhaps raises the question what it means to be released on time. Is this a matter simply of setting our watches to the right time? But actually, do we have to consider what the reason is for providing these variable release regimes? What could be the purposes served by different conceptions of release and recall? And perhaps then the idea that that is something that really needs to be addressed before we start to look at whether half time or 2/3 is the right time to be asking these sorts of questions. Fundamentally at the heart of this deeper question then also, I think, is the idea of whether we can conceive the parole system as an engine of change and social justice, something which I think several of our contributors have touched upon most recently in that discussion about the makeup of the Parole Board itself. To what extent that will form part of the review will be interesting, I think, to see. In addition to this question, we of course heard from the Vice Chair of the Parole Board, who perhaps encouraged us to reflect on the extent for perhaps slightly lesser degrees of change, maybe building on the improvements which we've already seen in recent years, and in fact affording the Parole Board the opportunity to take more control of the processes rather than perhaps going back to the drawing board. So I raise this perhaps as one of the points of perhaps a little bit of tension in some of the contributions we've heard today as to whether the level of the review needs to be fundamental or needs to be perhaps one of more refinement. It's particularly interesting, I think, to note the issue around involvement in sentencing planning. Perhaps there is scope for the Parole Board to take a much more active role, even in some of the other decisions beyond just release, and those sorts of decisions as well. I think in the second session, what we really saw then was that although there were some differences between Professor Fergus Mcneal and Dr. Joe Bailey in terms of how they conceived of rehabilitation and some of the concepts shared there, with Professor Mcneal pointing towards some of the wider aspects of rehabilitation, thinking about judicial and social aspects of that concept, I think there was quite a lot of parallel between the two contributions, perhaps raising this question: to what extent are we going to see in this review ideas about rehabilitation put into their broader context, with Dr. Jo Bailey providing us with a rich account of how public safety can perhaps be enhanced through some of the activities of the Parole Board, working in tandem with probation and indeed the prison service. And so I suppose one question was whether, drawing on those ideas about collaborative approaches with those who are serving sentences and appreciating the variation of their circumstances, whether those sorts of factors might need to be taken into account in a more holistic sense throughout the system, rather than just appearing at particular stages within an individual sentence, that maybe these concepts need to be more hardwired in, which again perhaps takes us through to consider whether really a review simply of the parole system is in fact sufficient, whether maybe a review of much wider aspects of criminal justice might really need to be something to background this discussion of parole against. Deeper questions, and I'm sure it won't necessarily be raising smiles to be suggesting even more fundamental and deeper views. Perhaps this is my own academic perspective running away with itself. I think it was then very interesting in the third session to really focus on this idea of public confidence. That appears to be one of the key aspects of the proposed review, to think about how it is that parole might benefit from having a greater degree of public confidence and public understanding. And of course, it's always very interesting to consider what data there is to go on. And Professor Julian Roberts was, I think, very clear in indicating that there is very little data that we have. Might it be necessary, therefore, prior to a review, to actually engage in some adequate data collection in order to support claims which may be quite latent within the review material, certainly within the recent consultation, about assumptions that perhaps opening things up to the public on particular case levels will necessarily lead to greater public confidence. I think this was something that both of our speakers in that third session really challenged in their own ways, with Professor Roberts highlighting the fact that with information being so low and knowledge being so low, there is scope here for a kind of populist retributivism to take hold, where there is great confusion about the underlying reasons behind parole decisions, and perhaps therefore that prior to engaging into opening up particular cases, it might be necessary to construct greater, wider education programs, following examples of jurisdictions like Canada, trying to really inform the public in a broader sense about these sorts of decisions, rather than perhaps opening things up at an individual level and risking some of the stories perhaps spiraling out of control and losing the ability to contextualize some of these decisions. Following on from that, it was very interesting to hear, of course, from Angela Cossins, how it is that it's a very complex relationship that the victim liaison officers have with the victims whom they support. And perhaps the idea that there are some real risks inherent in the idea of opening up parole decisions to wider public forums then, without thinking things through very carefully indeed. One might wonder whether opening things up to the public without the benefit of that advice and that context from victim liaison officers, whether once again that perhaps creates more problems with the capacity for the public to misinterpret what's being said. The idea that these very often technical decision processes and these kinds of professional activities necessarily are transparent in and of themselves to members of the public to access what is happening merely by broadcasting, merely by welcoming the public into that context, whether we need to think more carefully then about how to approach that part of the review. And I suppose this would really lead on to reflect a little bit about what we might be expecting tomorrow. I think that the questions that have been raised this evening feed very nicely into the issue of solutions that we will be looking at tomorrow. In particular, thinking about the values and aims that might underpin the parole system. I think it will be very, very interesting to hear what Professor Feldman has to say with respect to some of these values and aims and how they might relate to one another, how we might potentially even approach them in a more relative sense. But also, I think, as well as looking at some concrete examples or suggestions for reform in the first session, thinking more deeply about, again, this question of grounding the reform of parole in its wider criminal justice context, and how it is, whether it's really possible to have satisfactory reform in this area without looking more widely at sentencing as a whole, something which perhaps has been mentioned, I think, quite a few times this evening already, not only in terms of the complexity of our current sentencing system, and thank goodness we now have a sentencing act where it's all together in one code, but for anyone who's had a look at it, it is incredibly long, incredibly complicated, with some very complicated, difficult to understand types of sentence, which of course have their own implications then at the parole stage, with parole board involvement to varying degrees for these different types of sentences and at different points. So I think that's probably a good place to leave things for this evening. And in terms of my concluding remarks, I'd only like to add that I very much look forward to hearing what will follow tomorrow. And I'd like to add my voice of thanks to those who have contributed this evening.
Thank you very much, Tom. I have to say, I thought it was a really rich discussion this evening, and it's well-timed food for thought, given that we're right at the start of the root and branch process, which I think we're likely to be in for at least 6 months. Can I thank on all your behalf, we can't clap anymore, but can I thank all our speakers for their very interesting and thoughtful presentations. And I'd also like to thank all our participants for the really challenging questions that we got. And I'm sorry that I couldn't get through all of them. I'm sure there'll be an opportunity to ask questions again tomorrow. As I said, this is part 1. So we are going to reconvene again in 24 hours. So I really look forward, I won't be chairing, but I really look forward to joining in then. And your chair tomorrow will be Professor Lorraine Gelsthorpe, who's director of the Institute of Criminology. But until then, I hope you have a really good evening, and we'll reconvene, as I said, in 24 hours. Thanks very much. Bye-bye, everybody.